Tonight, there is new reporting that Donald Trump's Department of Justice is targeting E. Jean Carroll, the former magazine columnist Trump was found liable for sexually abusing in 1996. That's in front of a civil jury. Citing multiple sources familiar with the matter, CNN reports the DOJ has launched a criminal investigation into whether Carroll committed perjury in a 2022 deposition when she said she received no outside funding for her civil lawsuit against Trump for sexual abuse. The legal team around Carroll later disclosed that billionaire Democratic donor Reid Hoffman paid some of her legal fees. Of course, we don't know when that happened and when she answered that question. I should note, MS Now has not independently confirmed this reporting. CNN says Carroll declined to comment on the story. A spokesperson for the Justice Department did give CNN this statement, quote, "We can confirm that no U.S. Attorney's Office has declined to investigate any case relating to the subject matter of CNN's inquiry." No U.S. Attorney's Office has declined to investigate. We will not comment beyond that. Take that for what it's worth. MS Now senior legal reporter Lisa Rubin joins me now. Lisa, this reporting emanated from CNN, so we're sort of operating off the report they have. What can you piece together so far?
Well, Chris, this is an issue that actually percolated at E. Jean Carroll's first of the two trials that I attended. And we do know when she gave that deposition, and we also know, maybe more importantly, when her lawyer, Roberta Kaplan, then disabused Trump's then lawyer, Joe Tacopina and Alina Habba, of their belief that E. Jean Carroll had lied in her October 2022 deposition. I'm going to read to you from a letter that was sent to Mr. Tacopina's firm by Robbie Kaplan in April of 2023 on the eve of that first trial. And I think based on what she says in this letter, the notion that there's a criminal investigation into E. Jean Carroll is sort of gobsmacking. She writes, "It appears that you may be operating on a misunderstanding of the facts. As Ms. Carroll testified at her deposition, she had and continues to have a contingency fee arrangement with her counsel." And let me just pause there for our viewers. That means that E. Jean Carroll was not paying her lawyers as the case went along, but that the lawyers were themselves bearing the fees, and that if there was going to be a recovery, then they would get some percentage of that. Robbie Kaplan continues, "In September of 2020, well after Ms. Carroll filed her state court complaint in November 2019, that's the first lawsuit that E. Jean Carroll filed that ended up going to federal court because Trump wanted it there, not because she wanted it there. Then she says, counsel for Ms. Carroll secured financial support from a nonprofit organization that would help offset certain costs and fees in connection with counsel's work on Ms. Carroll's behalf. And here's the important part. Ms. Carroll has never met and has never been party to any communication, written or oral, with anyone associated with that nonprofit or its financial supporters." And let me then take a step back. The day before this letter, Robbie Kaplan had written to Alina Habba and said, look, in connection with preparation for trial, Jean now remembers something that is different than what she testified to when you took her deposition. She now remembers that she did know that we had secured some funding on her behalf. That doesn't change the fundamental fact of her testimony that she knew that this was a contingency fee case, and she wasn't aware at that time that anyone was paying legal fees in the case. She since has remembered understanding that we received some funding on her behalf. If this is the basis for a criminal investigation begun by the U.S. Department of Justice, now headed by former Trump personal counsel Todd Blanche, who, according to CNN's reporting, is recused, but now is being run out of the U.S. Attorney's Office for the Northern District of Illinois in Chicago. If this is what this is based on, I don't even know what to say to you and our viewers about this as a criminal investigation.
Yeah, I just wanted to take a step back because I really appreciate you sort of walking through the facts here as they're established. I mean, I feel a little bad because we sort of framed it because we kind of have to of like what they're accusing her. But like, I just want to say no criminal investigation or case brought by the Department of Justice against an obvious person that Donald Trump has a vendetta against should be treated at face value to begin with. Like, it's simply not rational. It's not logical. It's like, it's not a good faculty of judgment by anyone. Like, the obvious default that people should have is that it is purely out of spite and vendetta until shown otherwise, right? The rebuttable presumption. And this seems like one of the most aggressive and egregious examples. An 82-year-old woman who said that Donald Trump sexually assaulted her in the Bergdorf Bergdorf Goodman dressing room, who Donald Trump called a liar, who then sued him for defamation for lying about her, and then won. That's who we're talking about, that the Department of Justice apparently wants to criminally prosecute.
Let me make it worse, actually, if I can, because not only did she win, she won twice. She won 2 separate verdicts from juries comprised of people from all over, not just Manhattan, but from places in upstate New York. The juries were mixed in terms of gender. There were people on that jury, including one juror who I really remember well, who was a listener of Tim Pool. If you know anything about the podcast ecosystem, somebody who listens to Tim Pool on the regular is not exactly a Democratic voter. And yet, both of those juries unanimously held for E. Jean Carroll. And the Second Circuit, the federal court of appeals that oversees the court that tried these cases, also affirmed both of these verdicts. They then denied a review by all of the active judges on that. And now he's trying to get his case into the Supreme Court. And just as he is trying to get these cases into the Supreme Court, lo and behold, he's lobbing this fact of the investigation into the public domain. It strikes me as an attempt to influence the justices' thinking right at a juncture where it's pertinent. And Chris, one more thing here. The E. Jean Carroll case that's already been fully briefed to the Supreme Court, the justices have held over for their conference again and again. And again, for the uninitiated, the Supreme Court justices typically meet on Friday mornings to discuss applications for review. The E. Jean Carroll case has been scheduled and rescheduled now 12 times. It will be discussed again, or is scheduled to be discussed again on Friday morning. But I can't help but wonder what the timing here says about both the merits of the investigation, but also who the audience for the investigation is. Did they actually intend to prosecute E. Jean Carroll, or are they trying to send a message to the justices?